So one important thing for you to consider before stepping into the eviction court is that the entire process is riddled with delays. We're talking all about that today. Let's get started. So nobody enjoys having their time wasted in a process that, to be frank, was actually designed, particularly in the state of Texas, to go by quickly. Unfortunately, we live in a post-pandemic world where a lot of those ideas are just out the window. Originally in the state of Texas, an eviction was designed to last no longer than 21 days. Now we're lucky if we can get it resolved that quickly. Generally speaking, it takes about 30. So what sorts of things contribute to a delay in the eviction process? One of them is the docket itself. So not every case load is the same from court to court. My office is here in Houston, in the middle of Harris County, and there are 16 justices of the peace in this county alone. 16 different courts, and all of them have varying numbers of evictions on their dockets. Certain precincts are enormous compared to other precincts, and so their dockets reflect that. If the Justice of the Peace where you are filing has one of these enormous dockets, you can expect delay just because of the sheer volume of cases that particular judge has to get through. But let's say that the court has secured a date for you and you are now headed to trial. What other things can pop up and cause delay? Well, naturally, if there's some sort of emergency, either the plaintiff or the defendant, the plaintiff likely being the landlord, the defendant likely being the tenant, can request a motion for continuance. Now, the default rule is that a motion for continuance is only granted if both parties are in agreement. This often happens when there's some kind of settlement, but in the event of an emergency, it is possible that a party can file for a motion for continuance, even if the opposing party is not in favor of this continuance. The court can grant it in the event of an emergency, illness, hospitalization, some other factor that is significant enough for the court to decide, yeah, that's a good enough reason to give it another week or so. It's not usually longer than that, but if some emergency pops up, you can expect another delay. Another factor that often contributes to the delay in the eviction process is what's called service of process. Now, service of process is one of those fundamental rights. A person who is being sued in any court has the right to be informed of that lawsuit so that they can prepare a proper defense. In Texas, the eviction court requires that a tenant be given at least 6 days of advance notice of an eviction trial. Now, the truth is, they don't have to have actual notice. Constructive notice is okay. And what does that mean? Well, sometimes the tenant is either not wanting to be found or simply cannot be found for whatever reason. So for a tenant who resides on property, the court will attempt to execute service on that defendant. Generally speaking, in the state of Texas, a constable will come by, knock on the door, and seek to personally deliver notice in hand to the named defendant in the case. But that's not always possible. If someone is working during the day or simply out at the time the constable comes, the constable may return and never be able to actually deliver that notice. So in Texas, there is a process for alternative service. However, this process might end up delaying the trial date, particularly for courts that assign a case to trial with the assumption that the constable will be able to deliver service at least 6 days in advance of the trial. If that, for whatever reason, doesn't happen, your case will be reset to allow a defendant at least 6 days in advance of the trial. So what does this process look like? Typically, the judge will sign an additional order allowing the constable to go and simply tape the notice to the door and then issue the notice, a copy in the mail to the defendant. And it's possible that the defendant never actually receives it. Maybe they don't check their mailbox. Maybe someone else took the notice off the door. However, the court will deem that tenant having been served, even if they never opened their mailbox and actually looked at the citation, the court will deem that defendant served based on the order that allowed the constable to deliver the notice in this way, and the matter can proceed to trial so long as that notice was served at least 6 days in advance. If you're getting value out of today's video, please hit that like button. That helps us tremendously. And if you haven't subscribed yet, please consider subscribing. Another factor that can contribute to the delay in an eviction is an abatement. Sometimes the court issues an order to abate a case, which essentially is a pause button. The court will press pause on a case and hold off making a final decision based on all sorts of things, one of which is a lack of evidence. If, for example, one of the parties says, well, I have absolute evidence proving X. Now, generally speaking, the court's going to hold all parties to having all of their evidence at the time of trial. But there are certain circumstances that maybe prevent a party from being able to present that evidence. Many times, for example, a party, typically the tenant, will say something like, well, I want to hire counsel. Generally speaking, the court won't allow that. But in certain circumstances, when facts are uncommon, the court will allow a party to seek out counsel in order to properly defend themselves. With the evidence issue, again, if there's a factor where, for example, a party is prevented from getting evidence but does have access to it otherwise, the court may allow some time to allow the parties to retrieve that evidence, bring it to the court so that the matter can be heard properly. Additionally, sometimes matters are so complicated that the court itself has no experience or little experience in the matter, and the court has to seek out guidance for themselves. In this case, the court may abate a trial and take the matters under advisement. The court may go and seek counsel from other judges or even county attorneys to make sure that the ruling that they issue is in accordance with the law. Finally, the case may be put on pause because of some other issue being handled in another court. One very common basis for an abatement would be the filing of a bankruptcy. If a tenant is in the middle of a bankruptcy, the justice court in the state of Texas, or even the county court on appeal, loses its authority to proceed, and so the matter must be abated, and inevitably the process will be delayed while the matter is pending in the bankruptcy court or in some other court where some other matter that directly affects the eviction has to be decided first. In either of these cases, the Justice Court may abate the matter for resolution in one of those courts. The most common reason for delay in the eviction process is simply the fact that a tenant has filed for an appeal. In the state of Texas, every case that comes out of the Justice of the Peace can be appealed up to the county court. And because of this, many tenants elect, as is their right, to file an appeal and continue the process in front of another judge in another courtroom so that the case can be heard again. This process undoubtedly will take additional time. And so we tend to mention to landlords that you can expect at least another month, maybe 2 months, sometimes longer, of additional delay in the process if the tenant pushes forward and meets all of their deadlines so that an appeal can be heard in front of the county court. A less common tactic from one of the parties is to request a jury to hear the case. Sometimes a tenant will request a jury trial so that the matter can be presented to the jury, and typically those cases cannot be heard on the original date set by the court for a bench trial setting. The court will likely reset the matter to a later date, thereby delaying the process and extending the process. A jury trial typically lasts significantly longer than a bench trial, which could be over in as few as 5 minutes. But when a party requests a jury, and pays the requisite fees for the jury, the process is inevitably extended. Again, usually reset to a different date, and generally speaking, a significantly longer process. Sometimes a few hours, sometimes an entire day or longer, depending on the complexity of this particular case. Finally, user error will account for some portion of delay. Many cases are dismissed because of procedural errors committed by the landlord in the filing of an eviction. When an eviction is improperly filed by a landlord, the court can dismiss the case either at the justice level or later on appeal at the county court level, causing a tremendous amount of delay. This happens because of improper notice, or perhaps the court simply does not have jurisdiction to rule. This happens when issues of title come into play, where a tenant claims to be an owner, and that matter has to be resolved in some other court because the justice court simply cannot resolve issues of title, and the matter has to be presented somewhere else for resolution. In that case, the court loses jurisdiction and generally dismisses the case. Additionally, if a landlord simply lacks the evidence to prove the claims in their petition, the matter cannot proceed to a final judgment, and the court will dismiss their case or rule in favor of a defendant, again, when a landlord is unable to prove the facts of their case due to some lack of evidence. Naturally, if you have your case facts reviewed by a licensed attorney in your legal jurisdiction, you're going to likely avoid some of these very costly delays. Someone with experience can overlook all the facts of your case to make sure that you have sent proper notice, to make sure that any issues of jurisdiction are resolved beforehand, so you don't approach the justice court without a proper petition that can be resolved with a final judgment. If you are unsure whether your case is trial ready, I strongly recommend that you seek out legal counsel to have the facts of your case reviewed. For those of you interested in learning more about the eviction process, YouTube seems to think that this particular video is perfect for you as you continue to study landlording. And until next time, landlords, happy leasing.